The default process, turning non-response into enforceable judgment. 1. The moment silence matures. There's a difference between silence and default. Silence is what happens, default is what you record. When your lawful notice sits unanswered past its deadline, that's not the end of the process, it's the beginning of enforcement. So what does that actually mean? It means you don't win because they ignored you, you win because you prove they ignored you. In equity, time equals consent. Once the grace period expires, your unrebutted claims become truth in commerce. But truth unrecorded is powerless, so the executor must memorialize that silence. That's where the affidavit of truth enters the scene. Footnote. Default arises only when silence is documented, unrebutted facts become binding upon sworn attestation. 2. The affidavit of truth, your evidence of fact. The affidavit of truth is not argument, it's testimony. It says, I gave notice. They received it. They failed to rebut. Nothing more, nothing less. Simplicity is its strength. You attach postal receipts, return cards, and a copy of the original notice. Then you sign under penalty of perjury. So what does that actually mean? It means you turn silence into evidence. Once notarized, the affidavit becomes admissible record, your sworn statement of fact. No one can claim ignorance once truth has been witnessed and sealed. Footnote. A properly sworn affidavit converts silence into admissible proof of unrebutted truth under evidentiary law. 3. The certificate of dishonor, commerce speaks Latin. When a debtor fails to respond, he stands in dishonor. The certificate of dishonor formalizes that state. It's the commercial world's version of a court judgment, only faster and cheaper. The certificate declares that lawful offer and opportunity were given, and that no rebuttal or payment was made. So what does that actually mean? It means you just recorded your victory in Latin. This document shifts liability from claim to enforcement. Once issued, it can be notarized, filed, or lodged as evidence of completed due process. Courts call it tacit confession, commerce calls it dishonor. The effect is the same, binding admission by silence. Footnote. A certificate of dishonor establishes contractual default and finalizes the opposing party's liability through tacit confession. 4. The notice of default and judgment. This is where it all comes together. The notice of default and judgment. It's your formal declaration that the administrative process has reached finality. You cite the original notice, the fault, the affidavit of truth, and the certificate of dishonor, then declare the matter settled and judgment entered. So what does that actually mean? It means the record is now the court, and you're the clerk signing the judgment. From this point, your claim is enforceable under commercial law. You have moved from demand to decree, not through aggression, but through perfected process. Footnote. Notice of default and judgment finalizes administrative process, creating a self-authenticating instrument of commercial enforcement. 5. The seal of finality, closing the loop. The executor always ends in honor. Once default is complete, seal the record with your postal stamp and signature. File copies with the U.S. trustee or appropriate oversight body for notice and transparency. This isn't vengeance, it's balance. The goal is closure, not punishment. So what does that actually mean? It means you end where you began, in good faith, with clean hands. Equity rewards precision and integrity. When your record shows both, you've achieved the highest form of remedy, lawful peace through perfect process. Footnote. Properly sealed default records establish closure, preserving equity and good faith through transparent commercial remedy.